A debt collector just called you. There are 11 things they are legally forbidden from doing under federal law. Most people never know this. Today, you will. The Fair Debt Collection Practices Act, 15 U.S.C., Paragraph 1692 ATSEQ, a federal law enacted in 1977 and still fully in force. It exists because Congress found that abusive, deceptive, and unfair debt collection practices were causing. These are the statute's own words. In the congressional findings at Paragraph 1992 EA. Personal bankruptcies, marital instability, the loss of jobs, and invasions of individual privacy. That was the intent. The law reflects it. This video walks through the 11 core prohibitions drawn directly from Paragraph 1692C through 1692 OZEV, plus one additional right that sits in Paragraph 1692 UGRAN and that collectors count on you not using. Every claim here is from the statute. No secondary summaries, no blogs. This is legal education, not legal advice. For your specific situation, consult a licensed attorney in your jurisdiction. Before the prohibitions, who the FDCPA covers. Under Paragraph 1692A(6), a debt collector is any person who regularly collects debts owed to another. Third-party collection agencies, debt buyers, collection law firms. If a company whose primary business is collecting someone else's debts called you, the FDCPA almost certainly applies. If the original creditor, the credit card company, the hospital, calls you directly, FDCPA coverage is less straightforward. It may depend on whether they are collecting under a different name or have a separate collection operation. That is the Paragraph 1692A (NICS) analysis. When in doubt, who called you? If it's a separate collection agency, assume the FDCPA applies and document accordingly. Now, the 11 prohibitions. 1. Calling at hours the statute presumes inconvenient. Under Paragraph 1692CA(1), a debt collector may not communicate with a consumer at any time which is known or should be known to be inconvenient to the consumer. The statute specifically provides that, in the absence of knowledge of circumstances to the contrary, a debt collector shall assume that the convenient time for communicating is after 8 a.m. and before 9 p.m., local time at the consumer's location. A call at 7:55 a.m., the statute presumes inconvenient. A call at 9:05 p.m., the statute presumes inconvenient. That presumption is built into the law. The burden is on the collector to have a specific reason to believe otherwise. 2. Calling your workplace when your employer prohibits personal calls. Under Paragraph 1692CA(3), a debt collector may not communicate with a consumer at their place of employment if the collector knows or has reason to know that the employer prohibits such communications. Once you inform the collector, on the call, on record, that your employer does not permit personal calls at work, the legal obligation to stop calling that number attaches. Document when you said it and who took the call. 3. Contacting you after you send a written cease communication demand. This is one of the most powerful rights in the entire law. Under Paragraph 1692CCC, if you notify a debt collector in writing that you refuse to pay the debt or wish the collector to cease communication, the collector must stop all contact. After receiving that written notice, the collector is permitted to contact you only twice. Once, to confirm they are ceasing contact, and once, if applicable, to notify you of a specific action they intend to take, such as filing a lawsuit. That is all. 1 letter, certified mail, return receipt requested. Keep the green card. It is your proof of the delivery date and recipient. The cease communication right is federal law. Collectors rarely volunteer that it exists. 4 down, 7 to go. The next prohibition is the one collectors rely on people not knowing, because it happens without the consumer ever learning about it. 4. Revealing your debt to third parties. A debt collector may contact a third party, your relatives, your neighbors, your co-workers, for one purpose, to locate you. That is what Paragraph 1692B permits, to obtain your address or phone number. What the collector cannot do is reveal that they are attempting to collect a debt from you, name the creditor, or disclose the amount. Under Prohibition 1692b(2), the collector is not permitted to state that the consumer owes any debt. And under Prohibition 1692cb, except for your attorney, a credit reporting agency, the original creditor, or the creditor's attorney. Communicating with any third party about your debt is prohibited. If a collector told your employer, your family, or your landlord that you owe money, that is a violation. Document it exactly as it was described to you, with the date. Sections 1692d(1) and 2 and 5 cover harassment and abuse. 3 prohibitions clustered here. 5. Under Prohibition 1692d(1). No threats of violence or harm to your person, your property, or your reputation. Any explicit threat is an immediate violation. 6. Under Prohibition 1692d(2). No obscene or profane language. Deliberate verbal degradation, cursing, slurs, or language designed to demean is a federal violation. Document the exact words you recall immediately after the call. 7. Under Prohibition 1692d(5). No causing a telephone to ring repeatedly or continuously with intent to annoy, abuse, or harass. Multiple calls in a single hour. 9 calls before noon with no voicemail. A pattern across multiple days. This section exists precisely because the repeated call tactic is the most common form of collector harassment in reported cases. Your phone's call log is your evidence. Screenshot it. Date it. Every call. The next 2 prohibitions cover what collectors can threaten will happen to you if you don't pay. Know these word for word. 8. False representations about the debt. Under Prohibition 1692e(2)(a), a collector cannot make a false representation of the character, amount, or legal status of any debt. If the balance they claim is $1,800 and your records show $900, that is a false representation of the amount. If the debt is legally time-barred under your state's statute of limitations, and the collector represents it as currently enforceable, that is a false representation of legal status. The collector does not have to intend the misrepresentation for Prohibition 1692(2) to apply. A false representation is a false representation. If a collector tells you an amount that does not match your own records, request debt validation in writing. We will cover that right in a moment. 9. Threatening arrest or criminal prosecution. Under Prohibition 1692e(4), a collector cannot represent or imply that failure to pay will result in your arrest, imprisonment, or criminal prosecution when such action cannot legally be taken. Unpaid credit card debt, medical bills, personal loans. These are civil debts. In the United States, you generally cannot be arrested for a civil debt. Criminal prosecution for a civil debt balance is not a legal remedy available to a private debt collector. A collector who tells you that a warrant will be issued, that law enforcement is involved, or that you face criminal charges for not paying a consumer debt is representing that a legally unavailable action will occur. That is what Prohibition 1692e(4) prohibits. And under Prohibition 1692d(5), threatening any action that cannot legally be taken, or that the collector does not intend to take, is independently prohibited. Threatening immediate wage garnishment when no court judgment exists falls under this section. 10. Collecting amounts not authorized by your agreement or by law. Under Prohibition 1692(2)(1), a collector may not collect any amount, including any interest, fee, charge, or expense, unless that amount is expressly authorized by the original debt agreement and permitted by law, or is otherwise permitted by law independent of the agreement. This is how unauthorized fees get added to balances. A surcharge added by the collection agency. Interest calculated at a rate not in the original contract. An administrative fee with no contractual basis. If the balance you are being asked to pay is higher than what your original account agreement and applicable state law authorize, the excess amount is a candidate for a Paragraph 1692(1) violation. The validation process, which we are about to cover, is how you get the collector to show their math. 11. Failing to disclose that the communication is a debt collection attempt. Under Paragraph 1692(e)(11), in the initial communication with a consumer, whether oral or written, a debt collector must disclose that the collector is attempting to collect a debt, and that any information obtained will be used for that purpose. In all subsequent communications, the collector must disclose that the communication is from a debt collector. This requirement is sometimes called the mini-Miranda disclosure. Failure to include it is a Paragraph 1692 in violation. If a collector calls you, identifies themselves by name, and tries to discuss the debt without ever saying, "This is an attempt to collect a debt," that is the violation. This is not one of the 11 prohibitions. It is something different, a right that reverses the pressure. Under Paragraph 1692 GEA, within 5 days of their initial communication with you, a debt collector must send you written notice containing the amount of the debt, the name of the creditor to whom the debt is owed, a statement that you have 30 days to dispute the debt in writing, a statement that if you dispute the debt within those 30 days, the collector must obtain and mail you written verification of the debt, the name and address of the original creditor, if different from the current one, upon written request within the 30-day window. Under Paragraph 1692 GBB, if you send a written dispute within those 30 days, the collector must stop all collection activity until they have mailed you written verification. Many debts in collection contain errors, wrong balance, wrong account holder, debts already discharged, debts past the statute of limitations. The validation process forces the collector to document what they actually own, what it amounts to, and that it is yours. Your written dispute goes certified mail. Return receipt. The same green card rule applies. Let's put the FDCPA's civil liability provision into plain numbers. Under Paragraph 1692 KAA, a consumer who prevails in an individual civil action against a debt collector may recover actual damages, any documented financial harm the violation caused, statutory damages, up to $1,000 per action, regardless of whether you suffered actual financial harm, attorney's fees and the costs of the action if you prevail. The $1,000 ceiling is not a minimum. Courts set statutory damages based on the frequency and persistence of the violation, the nature of the violation, and whether it was intentional. But up to $1,000 is what the statute authorizes in an individual action. Here is what a documented scenario looks like. A collector calls at 9:22 p.m. on a Monday, calls again at 7:47 a.m. Tuesday, calls 4 more times Tuesday morning in a 2-hour window. Your phone log is time-stamped. You have a screenshot. That is too clear. Paragraph 1692 CA. U1. Violations, presumed inconvenient times, and potentially a Paragraph 1692 D5 harassment pattern, all from the same phone log. Now add, the collector never said, "This is an attempt to collect a debt," in the initial call. That is a Paragraph 1692 E11 violation layered on top. The individual action cap is $1,000 per lawsuit, not per call. But under Paragraph 1692 KA 3, a prevailing consumer is also entitled to, and this is the part that makes the law practical, the costs of the action, together with a reasonable attorney's fee as determined by the court. Fee shifting is built into the statute. Under this provision, the collector pays your attorney if you win. That is why many FDCPA attorneys take these cases at no upfront cost to the consumer. A well-documented case is worth their time even when the statutory cap is $1,000, because the collector also pays legal fees. The $1,000 number matters. The fee provision is what makes the $1,000 number actionable. If you believe a debt collector violated the FDCPA, here is the starting sequence. Step 1. Document every contact. Date. Time. the exact number displayed on your caller ID. What was said, as close to verbatim as you recall. Write it down immediately after the call ends, while the details are accurate. Your phone's call log screenshots should accompany these notes. Step 2. Know your state's recording rules before you record. Under 18 U.S.C. Parf 25 2D. The federal default for interstate calls is one-party consent. You may record a call you are a party to. Some states require all parties to consent. Know your state's specific rule before recording any call. Recording without legal authority can create its own legal exposure. Step 3. Use certified mail for written demands. Your cease communication letter under paragraph 1692 CCC. Your validation dispute under paragraph 1692G. Both go certified mail, return receipt requested. The green card establishes the exact date of delivery. That date matters for calculating the collector's compliance deadline. Step 4. File a complaint. The Consumer Financial Protection Bureau accepts debt collection complaints at consumerfinance.gov/complaint. The Federal Trade Commission accepts fraud reports at reportfraud.ftc.gov. Your state attorney general may have additional authority under state law debt collection statutes, which in some states are more protective than the FDCPA baseline. Step 5. Consult an attorney if the violation is documented. Fee shifting under paragraph 1692K IA 3 is what makes FDCPA cases practical. If you have time-stamped documentation of a paragraph 1692C violation, a documented false statement, or a pattern of repeated calls, that is exactly what this law was written for. A final note. And it has a hard deadline. Under paragraph 1692D, a civil action under the FDCPA must be filed within 1 year from the date on which the violation occurred. Not 1 year from when you discovered the violation. 1 year from when it happened. If a collector called at 9:15 p.m. on May 1st, the clock for a civil action on that call runs until May 1st of the following year. Document violations when they occur. Do not wait. Every video on this channel works the same way. Statute first. Plain English second. If you've ever felt like someone was using legal language to pressure you into something without telling you what the law actually allows, that's what this channel is here to fix. Subscribe for more rights explainers. Next video covers final paycheck law. What federal and state law requires your employer to do after you leave a job and what happens when they don't. This channel provides legal information for educational purposes only. It is not legal advice and does not create an attorney-client relationship. For your specific situation, consult a licensed attorney in your jurisdiction.